Good day everyone. So today we'll be presenting to you the Pollution Adjudication Board. The topics under this presentation are the general overview, legislative mandate or basis, the extent or limitations as to jurisdiction and or quasi-judicial power, the nature of proceedings, quantum of evidence, and due process requirements, and the rules of procedure. I am Krystelle Jessa Salazar and I'll be presenting topics 1 to 3. Alright, so why does Pollution Adjudication Board matter? Because it is imperative to fortify the National Pollution Control Commission to safeguard the populace against the escalating threat of environmental pollution. Only through enhanced vigilance and dedicated action can we truly protect our communities and preserve the natural world for future generations. The Pollution Adjudication Board in the Philippines enforces environmental laws and regulates activities that impact the environment, especially when it comes to population. It matters because of the environmental protection, the public health and safety, accountability for industries, the legal framework and dispute resolution, and the sustainable development. Okay, so at this juncture, we'll know the law or laws that passed by the government to mandate the Pollution Adjudication Board. So we have here the Executive Order 192, also known as Providing for the Reorganization of the Department of Environment, Energy and Natural Resources, renaming it as the Department of Environment and Natural Resources and for other purposes. Specifically, it's Section 19. The Republic Act 3931 or the Act creating the National Water and Air Pollution Control Commission. And lastly, we have here the Presidential Decree 984 or the law that amended the Pollution Control Law, Republic Act number 3931 and established the National Pollution Control Commission in the Philippines. Provided under Section 19 of the Executive 192 that there is hereby created a Pollution Adjudication Board under the office of the Secretary. The board shall be composed of the Secretary as chairman, 2 undersecretaries as may be designated by the Secretary, the Director of Environmental Management, and 3 others to be designated by the Secretary as members. The board shall assume the powers and functions of the Commission or Commissioners of the National Pollution Control Commission with respect to the adjudication of pollution cases under Republic Act 3931 and Presidential Decree 984, particularly with respect to Section 6, letters E, F, G, J, K, and P of Presidential Decree 984. The Environmental Management Bureau shall serve as the Secretariat of the Board. These powers and functions may be delegated to the regional officers of the department in accordance with rules and regulations to be promulgated by the board. So here are the jurisdiction or the quasi-judicial power of PAB. It is specifically provided under Section 6 of Presidential Decree 984. In the adjudication of pollution cases, the board has the power and authority to issue orders or decisions to compel compliance with the provisions of this decree and its implementing rules and regulations only after proper notice and hearing. So there must be a due process before the board make their decisions or judgment in a particular case. Make, alter, or modify orders requiring the discontinuance of pollution, specifying the conditions and the time within which such discontinuance must be accomplished. So the board has the power to change or alter their decisions once they are made. Issue, renew, or deny permits under such conditions as it may determine to be reasonable for the prevention and abatement of pollution. for the discharge of sewage, industrial waste, or for the installation or operation of sewage works and industrial disposal system or parts thereof, provided, however, that the Commission by rules and regulations may require subdivisions, condominium, hospitals, public buildings, and other similar human settlements to put up appropriate central sewerage system and sewage treatment works, except that no permits shall be required of any new sewage works, except that no permits shall be required of any new sewage works or changes to or extensions of existing works that discharge only domestic or sanitary waste from a single residential building provided with septic tanks or their equivalent. The Commission may impose reasonable fees and charges for the issuance or renewal of all permits herein required. It has the authority to serve as the arbitrator for the determination of reparations or restitutions of the damages and losses resulting from pollution. Deputize in writing or request assistance of appropriate government agencies or instrumentalities for the purpose of enforcing this decree and its implementing rules and regulations and the orders and decisions of the Commission. It has the power to exercise such powers and perform such other functions as may be necessary to carry out its duties and responsibilities under this decree. So, the other powers of the PUB not mentioned in Section 19 or Section 6 of PD 984 are issued to the city or provincial sheriff such writs of execution and promulgate rules and regulations. The expanded powers of the board is provided under Sections 45 and 48 of Republic Act 8479 and Section 28 of Republic Act 9275.
Hello everyone, my name is Minella Kae Martinez, and in this part of the video, we will be talking about the rules of procedure in cases handled by the Pollution Adjudication Board, or PAB for short. But before we go into the procedure proper, there are a few questions that we must first answer. So firstly, what is the nature of proceedings in PAB cases? Under Section 4, Rule 1 of PAB Resolution 2021-04, these proceedings are summary in nature, meaning it is conducted without much formalities for the speedy disposition of the matter or the case. The rules of evidence used in normal courts are not applicable to these cases, and the rules of court shall not apply except in a suppletory manner. The next question to be answered is, what is the quantum of evidence required in PAB cases? The quantum of evidence required in PAB cases is prima facie evidence. This refers to evidence that is not rebutted or contradicted, making it good and sufficient on its face to establish a fact constituting a party's claim or defense. Now, these proceedings are subject to the due process requirement, which is number 1, notice, number 2, the opportunity to be heard. And with that, we can now delve into the rules of procedure, which can be situated in PAB Resolution number 1, series of 2010, and also PAB Resolution 2021-04. So, how do we commence an action? This can be done in 2 ways. First, by filing a complaint with the board or the regional office, or PENRO, which stands for Provincial Environment and Natural Resource Office, or CENRO, which stands for Community Environment and Natural Resources Office. Secondly, it may also be commenced by the issuance of a notice of violation by the department, regional office, PENRO, or CENRO. This complaint will then be endorsed to the regional office, and an investigation will be ordered. The said investigation will be conducted by the regional office within 3 working days from the receipt of such endorsement. After that, a report will then be submitted to the board, stating the action taken by the regional office, results of the investigation, status of the case, and recommendations for further actions. When prima facie evidence of a violation is found, the regional director will issue a notice of violation against the respondent along with an invitation for a technical conference. The next step will now be holding the technical conference. So what happens in a technical conference? So the regional director or a duly authorized representative designated by him will preside over the technical conference and hear the case. This is where the regional office formally presents its findings and allows the respondent to contest the said finding or to execute a commitment to institute pollution control measures. After this technical conference, a period for compliance or mitigating measures will be given to the respondent. But within 5 days from the expiration of the compliance period agreed upon in the technical conference, the regional office will proceed in testing and monitoring to verify if the respondents complied with their commitments and the DENR standards. If the respondent complied, the board will impose fines based on the records elevated by the regional office. On the other hand, if the respondent did not comply, a cease and desist order will be issued by the board, directing the discontinuance or temporary suspension or cessation of operations of the establishment or the person generating such pollutants. So, a cease and desist order may be issued when there is prima facie evidence that the emission or discharge of pollutants constitutes an immediate threat to life, public health, safety, or welfare, or to animal or plant life, or if it greatly exceeds the allowable DENR standards as provided in guidelines established by the board. Now, there may be a question in your mind. Does the respondent have a recourse in this instance? The answer is yes. The respondent may file a motion for the issuance of a temporary lifting order subject to submission of certain documentary requirements. The PAB will then issue the said temporary lifting order for the purpose of sampling or implementation of a pollution control program. This order is only effective for a certain period, which is dependent upon the purpose of why the order was issued. A sampling will be done after the said period to verify the respondent's compliance. Now, if the respondent complies, fines will be imposed and the board will issue a formal lifting order. But if the respondent is still found non-compliant, the board will order the closure of the establishment, impose fines, and forfeit the bonds.